Our next speaker certainly has a fire in her belly. And in asking her how she would like to be introduced, she explicitly told me to dispense with the crap and just say that she's an Indigenous barrister. I'd like to welcome Munya Andrews.
Thank you for staying. It's been a long day, but I really appreciate it. And that was just such a moving speech by Jill, and I thank her very much for that. I suppose I'm a bit emotional too, but just a lovely display of humanity and the understanding of people that are disadvantaged, and it was just a wonderful story. But I'm going to have to ask you to help me out because I've been having problems with my fly all day. My trousers have been falling down. So please, don't let me embarrass myself. If you see it sort of slipping down below this orange thing, and I'm showing my jowage, which is our name for knickers, please tell me, go, Munya, pull your pants up. Please, okay. Nangamin Lari, Uran, Maban Amba, Najana Ninga Munya Andrews, Bari Uran, Bari Buru Garawa Buru, Jarajan, Nilil, Guljaman, in Western Australia. So just welcome you in my Bari language. Okay, so I want to say, look, I want to preface this statement by saying that I have such respect for Julian Burnside, but is it just me? Is it just me? Racism on one side and xenophobia on the other? I mean, I just thought, man, you're such an intelligent man, but you don't get it, do you? You don't get it. The problem in this country is racism, not xenophobia. And I called up a mate of mine and got her on the phone and said, can you look up xenophobia on the dictionary? And you've got to have good mates like this who'll do these things for you. And to explore this idea of this distinction between racism and xenophobia. Xenophobia is a fear or hatred of foreigners. And it's a bit of a euphemism that takes away the impact of racism in this country. It's like, get real, man. Get real. You've just heard Jill talk about the circumstances that Indigenous people find themselves in. Aboriginal person walking down the street in Mildura, gets picked up by the cops. Does he say, I've got a problem with a xenophobic policeman? I don't think so. He's going to say the racist, see? You know what I mean. But, and the other point that my solicitor friend said, and it's, Aboriginal people, you're not foreigners, you are in your own land. And that's it. It may be true of the immigrants who come here, that they're seen as foreigners, but we are in our own land. And it's not xenophobia that we face, it's pure racism. Let's call a spade a spade. And certainly, although Indigenous peoples have been treated as foreigners in this land, but these are the dangers of euphemisms. It's a bit like ethnic cleansing, when really you mean genocide. So, as students and as lawyers, you've got to question language that we use. I mean, that's the great thing about feminism that taught us about, really looking at language and challenging those assumptions about gender differences with rape. Why are women treated as somehow less than human? That's the real question. So, anyway, now, don't forget, you're looking out for my pants, aren't you? Okay, now, what I wanted to talk about today was the problems of communication that Indigenous people face in the Australian legal system. The Australian legal system, its laws, the values underpinning those laws, its protocols, its procedures, its physical makeup, e.g. the courtroom, its language and communication styles are culturally specific to white Australians of an Anglo background, and as such is foreign to Aboriginal people and others from a different ethnic background, and is therefore alienating. This symposium is about exploring legal ideas for creating a better world, presumably in the administration of justice, by making it more accessible and inclusive. While the creation of the Koori Court is a step in the right direction, many challenges remain. The focus of this presentation is to highlight specific challenges for the Australian legal system of Indigenous communication styles from an evidentiary point of view. In particular, the adducing of evidence through the use of questions by leading evidence in chief and in cross-examination. Many Australians often make the mistake of thinking that just because Aboriginal people speak English, that means we understand each other, right? Wrong. In fact, cross-cultural communication is oft fraught with difficulties, cultural, linguistic, and so on. In a brief session like this, of course, it's not possible to fully explore the complexity surrounding the issues, except to provide examples of situations where some of the problems arise. And one of the references that I was going to refer you to is the Aboriginal English in the Courts kit, which was produced by the Victorian Aboriginal Legal Service. But having a discussion with Jill just there on the side, and she said, "Oh, that's horrible!" And so I'm interested to hear what her opinions are about that. But anyway, I need to just mention that that's available. I'm aware, that we're probably running a little bit behind. So what I'm going to do is just go straight into matters of the adducing of evidence through use of questions of direct and indirect. I should point out that, of course, many of you are aware that as Aboriginal English speakers, there are specific English words that have a different cultural context and meaning for us, and some of them you'd be aware of, things like women's business, men's business, country, and so on. And another big difference in terms of criminal law is the use of the English word kill. In Aboriginal English context, it often doesn't refer to a homicide. It just means to hit someone, as in shib and kill him. Well, you can imagine the consequences of that. And I think that was raised in the Robin Keena case by linguist Diane Eade. But the adducing of evidence. Now, the use of questions in Aboriginal communities as a form of communication has largely been the focus of socio-linguist Diane Eade. And Jill goes, "Oh, it's all that anthropology stuff," and I didn't want to tell her my first degree is in anthropology and sociolinguistics. But anyway, there are two forms of questions, as we know, direct and indirect. On the whole, the most common form of the use of questions from a successful point of view in an Aboriginal context, culturally and linguistically, is indirect questions. Now, this is not to say that Aboriginal people never ask direct questions, because clearly they do. The difference is, essentially, as Eades points out, is that they fall within a particular kind of direct questions that she labels as orientation questions. So, for example, where are you from? Who are your people? Who's your mob? And that's about as far as it goes. Once you start to go beyond that, to delve further into a situation, what happens, and many of you may have experienced this as solicitors, is that you simply draw a blank for cultural reasons. By and large, they have to do with the fact that much information gathering in Aboriginal communities is done by indirect questioning, which is exactly the opposite, the direct opposite to an Anglo-Australian context, particularly a legal context, which relies solely on the use of direct questions as a means of gathering evidence. Eades writes about this in her article, You've Got to Know How to Talk, in John Pryde's Cross-Cultural Encounters, and she also describes a number of linguistic techniques that Aboriginal people use to get more information. I won't go into those, but you can look them up for yourself. What I want to do in this very short session is to identify other cultural problems involved in trying to elicit information from Aboriginal witnesses, not only through the use of direct questions, but from a cultural mindset that is different from Aboriginal peoples. One of the cultural differences I've identified between Aboriginal culture and whitefella culture, or Gadiya culture, as we say in the Kimberley, is the requirement of Gadiya to be more specific as opposed to generalising, as a general rule, but there are some exceptions, as we will see. And I thought I'd provide you with some examples. So you were at the scene of the accident, yeah, and you saw Mr. X's car hit Miss Y, yeah. What make and model was it? Now that would be valuable information for a legal practitioner coming from a Western perspective, but unless you're into cars, the question is really meaningless. And what it'll do is draw a blank and you'll get no response. And if you persist with that line of questioning, you will meet with resistance. For one, the Aboriginal person's way of thinking is, I told him it was a motor car, but he doesn't believe me. He thinks I'm a liar. He doesn't trust me. So to summarise, here is a perfect example of the difference between specificity versus generality. Once again, neither cultural way is right or wrong. It just is. There's a cultural difference that exists. Now you may say, well, there's many people in our culture too that don't know the make and model of specific cars. But I bet you that if the barrister or solicitor persisted in questioning, that information would come out, whereas it wouldn't with Aboriginal people. Example 2. The evidence may be that the witness walked into a bank. Which bank? Now, while the television advertisement worked very well for the Commonwealth Bank, the joke is lost on Aboriginal people. Again, it doesn't matter which bank it is. Now, you may say, yes, but Aboriginal people bank and must therefore know the name of their particular bank. Now, here's the irony. Most Aboriginal people do bank with the Commonwealth. Any reasons why? Centrelink, yeah, that's right, because that's the bank that Centrelink and other government agencies traditionally use. So the TV ad, which bank, is largely true, the Commonwealth Bank. But the humour is lost because, as a general rule, Aboriginal people don't understand irony as a form of humour. We have the Irish to thank for that.